Percentage co-filings.
Thank you, Mr. Speaker. And as members around this House will know, I want to begin, of course, by thanking all parties in this place and all members, even one voice that had said no, and I would not have this opportunity at third reading to speak to Bill C-51. So I'm genuinely grateful for the generosity of spirit in accepting this as a motion by unanimous consent. Having participated in the debates on C-51 from the very beginning, having been the first member of Parliament to declare firm opposition to the bill, I'm enormously concerned that we've made such little progress in addressing those concerns. Let me acknowledge from the outset that one of the first concerns I had was the use of the word lawful as a modifier for protests and actions in civil society. That word lawful has been removed, and that is a small improvement, but insufficient to deal with the dangers that are embedded in this act. Sitting here today, through third reading, I heard a great number of propositions from Conservative members of Parliament. I have no doubt that they believe those propositions in their speaking notes to be true, but they are consistently repeating fallacies that I'd like to try to explain and to deconstruct so that Canadians will understand why these repeated bromides are just not true. So these are the three fallacies that I want to address in the time I have, Mr. Speaker. One notion is that information sharing, which is part one of the bill, is designed to ensure that our security services, the RCMP and CSIS and Canadian Border Services and CSEC, that these agencies of policing and intelligence share information with each other. That was put forward earlier today several times, and that indeed is something that must be done, but this bill doesn't do it. The second fallacy, Mr. Speaker, is that there is judicial oversight in this bill because judges are involved in one section. I want to deal with that one as well. And the other one, as a fallacy, is that the terrorism and propaganda sections in the amendments to the criminal code in this omnibus bill will actually make it more likely that we can stop youth from being radicalized. Now, there are some things that aren't in this bill, and I want to mention those because I don't understand if the Conservative Party and administration was serious about avoiding radicalization, why they would not have followed the example of the United Kingdom. And not everything the UK is doing in this area do I endorse, but the UK, in December of last year, came up with a very specific anti-terrorism bill with proactive programs to go into schools and to go into prisons to find those people at risk of radicalization and stop them, prevent them, dissuade them. Now, we know that the horrific attacks recently in Europe were people who were allegedly radicalized in prisons. Why do we have nothing in Canada to deal with that? On the other hand, Mr. Speaker, what we have in place here are things that, and I'll get to this by starting with my last point first in terms of fallacies. The fallacy that the provisions to act to take terrorist propaganda off the internet will in fact stop radicalization needs to be understood in the context of a legal analysis of the words that are used. So in the section of the bill that deals with the criminal code and what I now call thought chill sections in Part 3 of the Act, what it says is that this bill will deal with something called promoting terrorism in general, which is not a defined term. And terrorism in general propaganda includes any visual image, it's general language. Now, legal experts who've looked at this are concerned about a couple of things. This business of getting things off the internet isn't brand new to Canadians. We have hate speech laws that take things off the internet, and we have child pornography laws that take things off the internet. In what ways have we constructed these provisions of terrorism in general in ways that are fundamentally different from what we did about hate speech and child pornography, which I would think we would all agree we take very seriously? Those kinds of laws have statutory defenses, and more significantly, those laws specifically exclude private conversations. This one does not. So you could be arrested, you could go to jail for a private conversation discussing things that in general, and it's very vague, could be seen to promote terrorism or might be reckless as to whether they promoted terrorism or not. Legal experts are concerned that this chill provision will make it harder for a community to continue to converse with someone who's at risk of radicalization, to stop them, to argue with them, to say your understanding of Quran is entirely wrong. We need to talk about this. By failing to exclude private conversations, we increase the likelihood that no one will reach out to that person, and we have no programs to deal with it. The second fallacy, Mr. Speaker, going backwards, is this notion that we have judicial oversight. We have no judicial oversight in this bill. First of all, one needs to understand what oversight means. And for this, I quote from a paper by the very dedicated law professors who took this bill on and have published hundreds of pages on it, Professor Craig Forsees and Kent Roach, who wrote this, quote, "Review and oversight are often confused. Oversight is a real-time or close to real-time operational command and control strategy. Review is a retrospective performance audit." So we can say that CERC provides review, although it's part-time employees, part-time members of the CERC board, and a very inadequate structure. But there is no oversight. We used to have an Inspector General for CSIS. The Inspector General for CSIS was done away with in Omnibus Bill C-38 in spring of 2012. Now, the term judicial oversight, as used by members of the Conservative Party in this debate, is truly a perversion of reality, because it's one of the most offensive sections of the whole bill, is the notion in Part 4 that if a CSIS agent, now with an operational role, what Roach and Forsees describe as kinetic functions, they go from collecting the data and the information to taking up disruptive activities themselves. When they do that, if they think they're going to break a domestic law or violate the charter, they go to a judge in a secret hearing and ask for permission to violate the charter. Now, you don't have to just take it from me, Mr. Speaker. Every legal expert who testified before the committee said that this was outrageous, that no other government, certainly none of our Five Eyes partners, allow their spy agencies to violate the Constitution through the simple expedient of going to a federal court judge in a secret hearing. Earlier today, the Parliamentary Secretary for Public Safety ridiculed a speech from the official opposition when they pointed out no one was there. She said, "How could anyone be there?" she said. Well, that brings me to a brief from a group that was excluded from giving testimony to the committee. The special advocates. Special advocates are security-cleared lawyers who operate in secret hearings, usually on security matters, to ensure the public interest is protected. These experts who were not heard before committee did submit written evidence urging that the bill be changed to ensure that we didn't have secret hearings with no one present other than the minister and CSIS. This kind of secret hearing, by the way, is particularly egregious because it's very unlikely to ever be subjected to judicial challenge. It will be hard to ever find out what happened in a secret hearing. It won't come before the Supreme Court of Canada and be struck down. Establishing standing for instance, a civil liberties organization to challenge this will be nearly impossible. That's why my position is so firm that this bill must be repealed if it should ever pass. The last fallacy, Mr. Speaker, is the really large one, that Part 1 about information sharing is going to make us safer. Now, first of all, another witness who was not allowed to testify is the Privacy Commissioner for Canada, Daniel Therrien. And he was very clear in saying that the breadth, I'll quote him here, the breadth of the new authorities to be conferred by the proposed new Security of Canada Information Sharing Act is overbroad and would allow departments and agencies to share personal information of all individuals, including ordinary Canadians who may not be suspected of terrorist activities. Now, this is an important point, but what the information sharing section does not do, which is critical if we want safety, if we want to ensure that Air India doesn't happen again, if we want to make sure that the spy agencies and the policing agencies are talking to each other so that they're not letting critical information be hoarded. And by the way, Joe Fogarty, a UK expert in security, testified before the Senate of recent examples on the public record where CSIS found out the RCMP was tracking the wrong people and decided not to tell them. Or CSIS found out there was a training camp and decided not to tell the RCMP, a training camp for terrorists. We need to ensure that these agencies share the information. Part 1 of this act allows agencies of government to share information about individual Canadians, but there is no requirement, no pinnacle control to ensure that an RCMP operation tracking terrorists has information and the benefit of information from CSIS. As a structural matter, experts from John Major, who was the chair of the Air India inquiry, to former heads of CSIS and former heads of CERC have all urged this bill not be passed as is. It's not too late. Please, colleagues, vote no to C-51.